In a medical malpractice case here in New York, what does it mean if an attorney gets up to cross-examine a medical expert and fails to ask leading questions? What does that mean? You want to know what it means and how serious this is? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In all likelihood, it means that this attorney is inexperienced. In all likelihood, it means that this attorney has not yet had an opportunity to really conduct cross-examination. Now, why is that? Because in any medical malpractice case, when we get up to cross-examine the defense's medical expert, the one thing that you will see really good, really experienced trial attorneys do is always ask leading questions. Doctor, isn't it true you graduated from this medical school? Yes. Isn't it true you went to this training program to do your residency? Yes. Isn't it true that you're licensed to practice in New York? Yes. Isn't it true that you are board certified? Yes. Those are all leading questions where I am basically putting words into the doctor's mouth, and now I want the doctor to simply agree or disagree. Doctor, isn't it true you treated my client on January 1st? Yes. And on that day, she made the following complaint. Isn't that true? Yes. And on that day, she told you about this problem. True? Yes. And she told you that she had this problem for the past 2 weeks. Isn't that correct? Yes. Now, what have I done? I've simply laid out a statement of fact, series of facts that we believe to be true, that we believe to be more likely true than not. And now the doctor has to only agree, disagree, or say that he doesn't know the answer. You will find that young, inexperienced attorneys are ones who don't know how to conduct cross-examination. They don't know how to lead the witness. They don't know how to ask leading questions. So instead, you will find that those attorneys, those young, inexperienced, naive attorneys, novice attorneys I should say, are ones who ask open-ended questions. Doctor, tell us about that. Doctor, what did you do next? Doctor, where did you go next? Doctor, why did you do that? They're asking open-ended questions. Who? What? Where? When? How? Why? Those are all great questions for your own expert. It gives our expert an opportunity to explain in his own words exactly what happened and why. However, you will find that the best trial attorneys, the best and most experienced attorneys in New York, they don't ever allow an opposing expert to go ahead and explain anything. I, as the attorney who's cross-examining the medical expert, have an agenda. And my agenda is to get the doctor to either agree with our set of facts or to disagree with them. That's my goal. I want him to understand that. And if the attorney is unable to do that, now he's got a serious problem. It means he can't control the witness. So now he says, Doctor, why did you do that? What he's done is he's opened up the door and gave the opposing expert an opportunity to explain. And I guarantee you, that expert will do everything possible to destroy this lawyer's case and his claim, to explain why they have no basis for a case. That's the danger with watching an attorney do that, especially a young, inexperienced novice attorney. On the other hand, you will find that the best trial attorneys are ones who never allow the doctor to explain. You ask short, tight, leading questions. Doctor, isn't it true you did this? Yes. Isn't it true you did that? Yes. Doctor, wouldn't you agree that in that instance where the patient makes the following complaint, that good medical practice requires that you do a detailed history? Yes. Isn't it important for you to record that history? Yes. Doctor, isn't it important for you to do a physical examination? True? Yes. Now, doctor, during the course of a physical examination, it's critical for you to examine the part of the body that the patient complained of. True? Yes. And once you obtain information about that physical examination, it's important for you to record those findings. Isn't that true? Yes. At least those findings that are positive, correct? Yes. And would you agree that it's important to record all of those positive findings? True? Yes. So what am I doing? I'm asking a series of short leading questions that get the doctor to say yes, no, I don't know, or I can't answer. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases as attorneys cross-examine expert witnesses. And you're sitting in court and watching an attorney do that, and he asks a series of questions that are open-ended. Doctor, tell us why you did that. What else did you do next? That's not appropriate for cross-examination. For his own witness, for direct examination, that's appropriate, but never, ever for cross-examination. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, What I encourage you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.